Hello, my name is Robert Goodwin, and this is Law on the Line. I'd like to welcome my guest, John Malco. And John is a relatively young lawyer, and he works as an attorney with the Simon Law Group out of Somerville. And John is going to be discussing the issues of adult guardianship. And John practices in that area, among other areas, I know. And he is a 2001, not graduate. You graduated from Penn State when, John?
2018.
2018, and he's been working with the law firm Simon Law Group since 2022. And you were a former law clerk, I know, for Judge Ballard in Somerset County. And you and I met through the Middlesex County Barnes Inns of Court, in which you and I are members.
Right.
And I really thank you for reaching out and becoming a participant on this series and offering your expertise. And so let's get right to it. Firstly, you have a background in education, you told me.
Yes.
And is that one of the reasons why you became interested in the field of guardianship, or as a field of interest in your practice?
Yeah, I think that a lot of people would really benefit from understanding the legal process better. And so with all of my cases, I try to explain to my clients what we're doing and why and what we're doing next. And with guardianship cases, it's not exactly a majority, but a significant portion of guardianship cases involve people who are now becoming adults, but still need someone to help make decisions for them. And so there are also a lot of guardianship cases that arise from people who are of any age.
True. But you really could see the transition of a young person in high school, for example, who has disabilities, and then becoming an adult, and how do the parent or parents tend for those children?
Absolutely. So I've talked to so many parents who have always made a decision for their child, and I often tell them they're still your child, but they're no longer legally a child. And so we have to go through this process to put you in a position where you continue to have the authority to make decisions for them.
So you indicated there are certain conditions that would perhaps require the need for a guardianship, and cognitive impairment, intellectual impairment, developmental disabilities, mental illness, drug and alcohol abuse. But I want to focus on right now, as using your expertise as a educator early on in your career, what happens when a young person who has been identified as having a disability in high school, whether it's autism or some other disability, transitions out of being a child into adulthood, and now the parent says, "What do I do now?" So explain that process to me.
Yeah. So at one point, I was planning to dedicate my career to the classroom rather than the courtroom, but I saw from my experience as an educator, and I used to serve on my local board of education, that there are a lot of students who benefit a lot from the special education programs we have in our schools. And so even though they've reached the age 18, many public schools will still continue to have programming for students with disabilities until age 21. But again, legally, an 18-year-old is an adult. And so they have to go through this process to get a guardianship. Now, if that student, that young person, is already receiving benefits through the Division of Developmental Disabilities, that's one of the divisions of the Department of Human Services here in New Jersey. If they're receiving those DDD benefits, then the guardianship process is somewhat simpler. It's somewhat easier. You submit your IEP, your Individualized Education Plan, which would have been developed between the parents and the teachers and the school district. And so you submit that IEP, and you submit a certification from a doctor attesting that the person is, in fact, incapacitated and needs someone to serve as their guardian and to make decisions on their behalf.
And that submission is to a court, is that correct?
Yes. So you would make the submission through your local county surrogate's office. Each of the 21 counties of New Jersey has a county surrogate. They're elected on, I think, every 4 years.
I believe so.
And when you apply through the surrogate's office, just as you would if you were filing an adoption or if you were filing for
Probate.
an estate, the probate process. And it is a probate judge who will hear your case. This is within the Chancery of New Jersey. And so a Chancery judge will hear that case, and there's a process that we go through in order to have the guardianship.
Okay. So we are going to talk about it a little bit more thoroughly, Title 3B.
Yes.
But that is to be distinguished from what you just said, the Division of Developmental Disability.
Right.
And when we were talking a little bit before we went on air, you were just really giving me an education about the distinction between the two. One thing that I'm going to ask you is, in your practice and with your experience, do many students or parents of students who find themselves to have some disability, have some incapacity, how do they find themselves in that DDD path, which seems to be a very, very good path to be in, to attend to these difficulties, issues, before, where they don't have to file a Title 3B application? Right.
So many parents are very adept advocates, even better than some attorneys, at advocating for their client, except they're advocating for their child. And so they've learned all the resources that there are available to them, and they really do a great job of insisting that this child gets exactly what they need or exactly what they would benefit from. And the Division of Developmental Disabilities offers a lot of programs, but not everybody knows all the services that they may be entitled to and all the programs that they may benefit from. So I always encourage my clients to, among other advice that I have for them, to consider going to the Board of Social Services in their county, talking to somebody there, a member of the staff, about their circumstances and learning about what other programs they could benefit from. A lot of times people who are getting DDD benefits, that's Division of Developmental Disabilities, they are getting those services from a very young age because they've been identified as having a disability. But I have had clients who may have autism or may have another disability and are aging out of the school system, or they've aged up to being legally an adult, and they haven't received these benefits because maybe they weren't aware of them. And so we'd have to do an ordinary Title 3B guardianship, which is just the statute for probate and for guardianship.
We'll get into that in a minute.
Yeah.
The question is, I have is the interface between the school district that you've seen, or districts, and the Department of Developmental Disability. You said through the Board of Social Services. Is there a strong connection between the two, or
there is a communication?
Yes,
certainly.
Communication.
Yeah, absolutely. And then some folks will just find the resources themselves, whether through the Board of Social Services or through the Board of Education, or they can contact them themselves if they wanted to. It's there are services that everyone in New Jersey may be able to benefit from, but these specific services are for individuals who are disabled, and they may be able to start offering funding and support for programs and for aids or for other assistance, even devices when people have mobility issues or might need hearing aids or visual aids or any number of things that the DDD services can offer.
In addition to, and they may not be deemed to be incapacitated if they just maybe have a hearing disability or sight disability.
Yeah, we'll get into the different levels that we talk about here.
Let's go, because you provided me with an excellent outline. And I want to now go and talk about the process.
Sure.
So the commencement of the process and the parties who are involved, and some definitions. One is AIP. What does the AIP stand for? And who are the parties to this to the legal process? How does it begin? And through Title 3B.
So a guardianship process is not just the appointment of the guardian, but also the finding that someone is incapacitated. And so when we're talking about the AIP, we're talking about the allegedly incapacitated person, because until they're adjudicated as having been incapacitated and needing a guardian, we refer to them as the AIP. After the guardianship has been entered and there's been an adjudication that they're incapacitated, then we'd refer to them as the IP, the incapacitated person, because there's been a finding that this person has been incapacitated and needs a guardian to make decisions on their behalf.
And
So
who
they're
do-
really
go
at the
ahead.
center of things. And
Right.
the guardianship process is very much, in some ways, about giving those people a voice or helping them to articulate that voice through another person.
So how do we do that? What's the legal process that you can instruct our audience if they have a young person, or for that matter, any age where a person is suffering from dementia or other physical disabilities that incapacitate them? How do
Yeah.
they go about doing
I
it?
mean, I've seen guardianships at all ages, and I think that it's really kind of an inevitability. If you live long enough, you're going to need a guardianship. The odds are in that favor. So the process starts with filing a verified complaint. You file it through the surrogate's office, and the New Jersey has been very helpful in this respect because they've created a set of forms. It's about a 37-page packet with instructions. Most of the pages are just instructions and definitions to help you fill out the forms, and it's not all that time-consuming. It ends up being a small stack of paper about this thick that you have to file, along with a filing fee. And another thing I should mention about the DDD applicants is that they don't have to file a fee when you file for guardianship. The ordinary guardianship costs $200. You pay a filing fee to the county surrogate, and they process the guardianship case.
That's a one-time fee, correct?
One-time fee.
So you mentioned forms. Where would one find those forms?
You can get them online, or you could get them through your surrogate's office. Some attorneys will use forms that they themselves have created, but I find that many of the surrogate's offices really want you to use the standardized set of forms because they're more predictable and they cover everything that you need to cover. And so that's what I generally use when I file guardianship cases.
And they're prepared by the administrative office of the courts?
That's
Is
right.
that it? Okay.
Yeah.
So there are these forms that you can get. So explain what you do. How does it go about now to the point where, up to the point of getting a court date down the road?
Right.
Go
So
ahead.
those are all the forms that you're going to be submitting. And you always have to sometimes assume that the court doesn't know anything about your specific circumstance.
And they usually don't.
Right. The court isn't all-knowing, even though they have all the powers necessary to help you in your situation. So you start by filling out a case information statement, which identifies the AIP, the person who's seeking a guardianship, and the person who is proposed as a guardian. You also identify who their next of kin are, because if I was seeking a guardianship over you, you might have a wife or a brother or a mother or a sister or a child who says, oh, wait, I didn't know about this. I should be the guardian. Who's this guy, John Malco, who should be guardian? I know Bob much better than John does, and so I should be the guardian. And so everybody is entitled to notice, and the court is able to provide that notice by knowing who all the people are. They also need to know about the assets that the AIP has. So some folks are very well off, but they may be suffering from dementia, or they may have a drug or substance abuse issue, and they've rendered themselves incapacitated, but they still have a lot of assets. And so you have to provide your information on that. And maybe the certification of assets says, I don't know what they have. But more likely, this person is a close friend or a relative, and they're able to provide a good insight into what the assets are.
So we have certain terminology. The person who's seeking to become the guardian is, I guess,
The plaintiff and proposed guardian.
Proposed guardian. And then you have, at the outset, the alleged incapacitated person.
Yep.
Is there any priority given to next of kin, an order of priority over a third party coming in? Because you mentioned the notice. So if you were a very close friend of mine and you felt that I needed to have a guardian appointed because of my apparent alleged incapacity, and I have either a spouse or a sibling, and they're sort of standing in the wayside, not really moving on that. What you said the notice. Tell me a little bit about that, because that becomes a contested guardianship.
It can be.
Talk about that.
There are a few different ways it could be contested. One might be somebody else says, oh, that person is incapacitated. I agree. They need a guardian, but it should be me. Or it should be me and my brother. We'll look after mom. We'll look after dad, whoever it is. Then the person themselves could say, oh, heck no, I'm not incapacitated. I don't need you to make decisions for me. And so that person, if somebody's seeking a guardianship over you, you have the right to demand a jury and to have a trial on the issue of incapacity. And you could have your own experts, your own doctors come in and say, this person's fine. They don't need a guardian. And so those are more hotly contested cases. there's some degree that people self-sort, and the people who come to me saying, I need a guardianship, I have no doubt that they do, in fact, need a guardian, whether it's somebody with dementia, somebody with a substance abuse issue, somebody who's suffered a stroke and is now in a largely vegetative state. I've had all kinds of situations like that. Or I've had folks who are very young and suffer from some kind of developmental disability, and they want their parent to continue to exercise decision-making power for them, and so they have to do that.
Or their parent wants to exercise the
Correct.
decision-making power.
Yeah, and so you want to make sure that everybody who's involved in their life has notice. Sometimes my clients will say, oh, well, my brother's not involved. And I would say, yes, but they still have to be noticed. We still have to make sure that they're entitled to have a word in edgewise and to have some say in the decision. But the court is the one who gets to decide, and the person themselves, say, if many years from now, hopefully, if I need a guardianship, they could look at your will and you could say, well, there's a designation of guardian, that if I ever need a guardian, I want it to be my wife.
Okay. So the process is you file the complaint, you pay the $200 to the surrogate, and what is the next steps along the way?
Right. So I have often had clients will come to me and they'll say, well, this person is incapacitated, they need a guardianship. I said, yes, I believe you, but the court isn't going to take my word for it, and they're not going to take your word for it. They need a doctor. They need a professional. And so the ordinary guardianship, you need 2 doctors or 2 psychologists or one of each to provide certifications. And again, there's a standardized form that the state has provided where you can give this to the doctor. The doctor will fill out their name, their qualifications, when they examine this person or how long they've been treating this person, and what their prognosis is, whether they're going to get better, and so that the court can make a decision based on that evaluation whether this person is in fact incapacitated.
How contemporaneous must the doctor's certifications be with the application?
So that's actually really important, and it's one of the only tight time constraints you have. Under the statute, you have 30 days. So the evaluation should have occurred within 30 days of the date that you're filing the application. And so what I usually recommend to people is fill out the application, get it to me, and I'll take a look at it, and then get the evaluations. And as soon as we have the evaluations, we'll go and file. Now, the court can relax that rule because the court has the power to relax those rules. And you explain to them, it took some time to get 2 doctors together to provide these evaluations. And if it's not dramatically over the line, then it shouldn't be a problem. But 30 days is the time limit.
From the
date of the evaluation to the date of the application.
So now you make the application, you have the evaluations. Are they all submitted as part of the package?
That's what I do, yes.
Right.
You could submit them piecemeal, I suppose, but I recommend you do everything together. And the surrogate staff is usually very helpful and outward-facing. They're very eager to help people. And they will tell you if they need more information or if something's not completed properly. They're not just going to send the whole thing back and not tell you anything.
Right. You don't get the envelope back in the mail with no notice or instructions. I know that the alleged incapacitated person is entitled to have an attorney.
Yes.
Talk about that. And who are these attorneys and how are they appointed? Who pays for them, et cetera?
So one of the documents that you submit when you file for guardianship is a proposed order for the court to enter. Because usually there's just one hearing on a guardianship case. If it's contested, it's likely that there will be more than one hearing. So when you submit this order to the court's initial order will set a hearing date, and it will appoint an attorney on behalf of the AIP. So the person who needs a guardianship is going to have an attorney appointed for them. They have the right to hire their own attorney, of course, but even if they don't have any, if they don't jump up and hire their own attorney, the court will appoint one. And that's usually somebody from the Office of the Public Defender, which will be appointed at no cost, or they can appoint a private attorney who will be appointed usually at a reduced cost, and that attorney will be appointed to represent the AIP's interests. They'll have to go and meet with them, talk with family members, and make an assessment and provide a report to the court to say, yes, this person who's the proposed guardian, they're the parent of this child with a developmental disability. I absolutely think they're a natural fit. I don't find any stated animus or desire from the guardian for the AIP to have another guardian, somebody else involved. And so I give my blessing. Contrarily, the AIP's attorney might say, well, the AIP told me that they actually have a bad relationship with this guardian, and they're very contentious with each other. And so I think maybe having a co-guardian would be appropriate, so that there's not just this one person who's now put an authority over the guardian, over the AIP. Or they may say, I think a less restrictive form of guardianship is appropriate, maybe something like a conservatorship, where the guardian would just be able to make financial decisions. Or maybe a power of attorney would be appropriate rather than a guardianship. It's somewhat less restrictive.
Where the person is deemed to have capacity to make decisions and to delegate them to a third party. That's
Right.
the power of attorney.
Right, that's the big distinction. The other big distinction, the way I often explain it, is a power of attorney is permissive. It gives you the authority to make decisions for me. You can. With a guardianship, you have to. You are now in a position where you need to carry that responsibility. You are appointed by the court, and you have to make decisions to the court. You're accountable to the court, and you have to make annual reporting requirements.
Okay, that's the point. Talk about the annual reporting, because of so now the guardian, the court reviews all the documents.
Mm-hmm.
Is there is it done on the papers? I know years ago we had to go to court for the final hearings.
Mm-hmm.
Are they done in open court today, or are they heard on the papers? Or Zoom?
So I've had a lot of them conducted remotely.
Yes, okay.
I've only in a few instances had to go in person for a guardianship proceeding, and I only remember one or two where they were done on the papers.
Okay.
It depends on the county, on the individual judge, on the individual surrogate's office, I suppose. But usually there is a hearing. It's a brief hearing.
And who testifies at the hearing?
So the proposed guardian is most likely to testify, and I would want to make clear on the record that the person understands the responsibilities that they're undertaking, that they don't foresee any conflict with a proposed co-guardian, that they have the person's best interests at heart, that they understand what they're going to need to do going forward in terms of reporting. And usually the reporting requirement is on an annual basis. It's, again, like a form that's been promulgated by the state of New Jersey on the guardian's well-being or on their finances. And it really depends on the circumstances, what you're going to need to do.
And where is that form filed? With the county surrogate?
With the county surrogate.
Nothing is filed with the state. Is that correct?
It's through the county surrogate's office,
okay.
not through the state, yeah. There is an Office of Guardianship Services at the state level, and they sometimes could get involved, I suppose. If you neglect to file your report on well-being, you'll get a letter notifying that you need to do that, and then they'll take additional steps to make sure that you do file, and you keep in touch.
So you brought something to my mind involving the public advocate's office in each county,
Mm-hmm.
and the Department of Aging, is it called?
Yep.
And I know they get involved in many guardianship applications. I know what's the distinction there from what a Title IIID, Title IIIB that you would be filing?
So the overwhelming majority of cases in New Jersey are filed by private attorneys or by individuals of the public. My understanding is less than 10% are filed by public agencies. Now, the Office of the Public Guardian exists in cases where maybe you don't have a close friend who you would trust to make these decisions for you, or the person doesn't have next of kin. Maybe they're the last member of their family. And so the Office of the Public Guardian could appoint a member of the state staff, a state worker, to serve as your guardian, and they would check in on you, and they would be under the same obligations that any other guardian would.
Very good. So, and those are people that really don't have that network or of next of kin, a spouse, sibling, to assist them.
Yeah.
What is the approximate expense for a private application for a guardianship?
So,
including the fee that who's paying the doctor that is hired?
that's sometimes a major point of concern for some of my clients. if you already have doctors who are treating you, you might not need to pay more. But if you have to hire an attorney or a doctor specifically to do the guardianship and to do the guardianship evaluations, you could end up spending a couple $1,000s on each of the attorney and on each doctor. So the cost could be significant.
What about the attorney who's appointed for the alleged incapacitated person?
So my experience is that when it's a private attorney, it's usually, I would say, $1,500 to $2,500. They don't have to spend a ton of hours necessarily preparing the guardianship report, and that's an average, I would say. But you could have an attorney that's appointed at no cost. It tends to take somewhat longer, the guardianship process from start to finish, when there's an attorney appointed at no cost, just because they have a limited bandwidth and there's a backlog of cases.
And the doctor who is appointed by the court to represent the interests of the alleged incapacitated person.
The attorney, yes.
The attorney, I'm sorry, could conversely have an interest, well, not an interest, but their duty is only to their client.
Absolutely.
And they can make a recommendation. I think you indicated that something lesser could be ordered, or recommended, not ordered, a conservatorship, or even or nothing, perhaps. Have you ever been in a situation where the doctor has said, "Look, I just don't believe this person is incapacitated"?
I haven't had that circumstance, just because I think many of my cases, people know what they're dealing with, and they know that this person needs help and that they want to seek a guardianship, and so
You're vetted, in effect, by them and by you.
Right. I have had circumstances where the AIP will say, absolutely not, I won't be evaluated. And there's a provision in the statute to address that, where you only have to have one doctor attempt to evaluate that person. And if they refuse to be evaluated, or if the facility or the people who have custody of that person refuse to have them evaluated, then the court can order it.
Okay. Well, I got the 1-minute signal about 30 seconds ago. So any concluding remarks that you want to make to enlighten our audience about the process? Feel free. Anything that we might have not covered. I know we could spend another hour at least, but
it seems to me that guardianship cases are really intended to benefit people who need somebody to advocate for them. So I encourage anyone who thinks they know somebody in a situation like this to talk to their Board of Social Services and to seek out advice from their county surrogate's office to see what benefits and what services they may be able to what may be appropriate for them.
And it may not be any more onerous an obligation than you had while you were caring for that person anyway.
No, you might be able to get some help, really.
And more help.
Yeah.
Well, I think that time is run, and I thank you very much, John. It was always very enlightening to talk, about subject matters that I know much less about, and you did a wonderful job informing our audience. And I don't know, we could always add this on. How can people reach you at the law office of Simon Law Group?
Yeah, my office is in Somerville on High Street,
and your phone number is
800-709-1131.
Thank you very much, John.
Yeah, absolutely. Thanks for having me.
My pleasure.